Good evening, everybody.
That was a while ago.
Thank you so much for joining us for International Law Weekend 2024. My name is Leila Sadat. I'm the current chair of the American branch of the International Law Association. And as I was flying in from St. Louis, where I teach international law at Washington University, I was reminiscing about my very first ILW, which was, I think, 30 years ago. So it's been a long time, here in the New York City Bar Association building. And since that time, ILW, this weekend, has grown considerably. We cover 37 panels, keynote addresses. We have to move to Fordham Law School because we have 1,300 registrants for this conference now, including all of you. Thank you. And it's really, for our board and for the organizers, it's really been a labor of love for all of us. This year is a particularly, I think our conference is on a particularly auspicious day. It's United Nations Day. It's the 79th anniversary of the entry into force of the United Nations Charter. I was over at the UN today, and the mood is determined and somber. And I think that fits with the theme that was so appropriately chosen by the co-chairs of the organizing committee, that is powerless law, or law for the powerless, and what is the status, the state, the effectiveness, the importance of international law today. Freddie Surgens, Madeline George, sorry, I'm blanking, Warren Biniford, who are our three co-chairs, have worked unbelievably hard. We've all put in a ton of time on this conference, and I think you will benefit from their hard work, from the diversity, from the longevity, in a sense of longitudinal and deep conversations that you'll have about every aspect of international law, whether it's arbitration, state responsibility, war, climate change, outer space, law of the sea, trade, intellectual property. Every aspect of international law is going to be in the weekend program. The theme, and again, I was over at the United Nations today, and it was both determination that was evidence and a lot of worry about the state of the world. We have wars that are ongoing in several regions of the world, judgments of the International Court of Justice that are being ignored by the warring parties, arrest warrants of the International Criminal Court that are being ignored by states, even states parties to the court, and even national courts and national systems are pushing back to some degree against international law. At the same time, we are a community of international lawyers, students of international law, practitioners, academics, and we believe that law matters. And so what we believe is that when it gets tough, and it gets tough sometimes when you see court orders that are unenforced and you see victims dying by the tens of thousands as the bombs fall, we believe that law still matters, and it's our job as lawyers to work even harder so that international law and international institutions can become more and not less effective. I wish you all a very, very successful conference. We will be around for the whole weekend. Please do come to as many of the panels as you can, to all of the social events that you can, because international lawyers also know how to have fun. And please do join us for our members meeting on Saturday morning, where we will give awards to distinguished individuals who have earned our Outstanding Achievement Award, to authors of significant books who are getting book awards, and of course our service award for individuals who have devoted time and talent to this organization. We're proud to be the American branch of the global ILA, et la lumière fut, right? The light came on. And we're very proud to be part of a 5,000 strong group of international lawyers with 66 branches all over the world. So thank you again for coming. I hope you enjoy the weekend. It's now my pleasure to introduce the next individual who will welcome you, and that is Mohammed Faridi from the New York City Bar Association. He's their president, and we've been coming to this location for 40 years to host our conference. So we're very proud to introduce the president of the New York City Bar Association. Thank you.
Good evening. I'm going to raise this a little bit. My task tonight is relatively simple. It's not to speak about international law. Be the issues relating to international law be thorny and vexing and perhaps interesting and thought-provoking. That is outside of the scope of what I will speak about in the short moment that I have here. My task simply is to welcome you to our association. Welcome. Our association is about 154 years old, and we fancy ourselves as one of the most prominent bar associations in America and perhaps the world. I think that one thing that adds to our prominence is the fact that we have been given the honor in the last 40 years to host this particular reception every single year for the last 40 years. And I hope that we're continue to be given that honor on a going forward basis, and I hope that our organizations have other ways to work together. Our organization has over 24,000 members and about 154 committees that focus on substantive areas of the law, including international law. So there are a lot of opportunities for cross-pollination. I looked through the program agenda for this year's theme, and there's two things that stood out to me. The first theme is the actual theme for this year's gathering: powerless law, or law for the powerless. And as a student of international law and sometimes a practitioner of public and private international law, I confess that I too sometimes wonder whether the rule of law at the international level faces an existential threat. I too sometimes wonder whether our system is capable of protecting the vulnerable, the marginalized people against aggression, hunger, and exploitation. And I too sometimes wonder whether the framework that currently exists can provide the powerless with a platform to advance their rights and interests. In some ways, I feel as dismayed today as I did back in 2003 during the lead up to the Iraq War, when many around the world felt that the international structure was not capable of protecting the marginalized people from aggression and brutality. So there is no better time to clear the misperceptions that relatively lay people like me have about the potential and the power of international law, and to underscore that it is possible through engagement and advocacy to use international law to rebalance the inequities that exist in our world. The second thing that stood out to me when I looked through the program agenda is the super, super impressive list of folks who are leading the discussions. Impressive not just based on their credentials, but also for another reason. I read the monograph that was written by Rosa Brooks a couple of decades ago about her tenure at US State Department in the 1990s. And she noted that when it came to the more traditional subjects of international law, state sovereignty, international security, territorial integrity, the world of international law was a very much a male-dominated world. And more recently, if you read the seminal work of Hillary Charlesworth and Christine Chinkin, they emphasize that the absence of women in the development of international law has produced a very narrow and inadequate jurisprudence that has legitimized the fundamental inequities that exist in our world. And the call for a dramatic rethinking of international law, this time through the inclusion of the marginalized, the powerless, and those who were previously excluded from the conversation. So that brings me back to the pamphlet for this year's program. It is one of the most inclusive programs that I have seen in the last several years, and you have set a really high bar for the other professional associations in our world. So I hope that you all have a very productive set of sessions in the next several days. And I hope that in those sessions you at least begin to address the many issues that Hillary, Christine, and Rosa have flagged, and perhaps equally important, to clarify the misimpressions of international law that relatively lay people like me have, and underscore its potential, to use the words from your pamphlet, to underscore its potential in balancing power through principles of justice, equality, and dignity. Thank you.
Well, thank you so much, Mohammed. For those of you who don't know me, I'm Michael Scharf, former Dean of Case Western Reserve University School of Law, and for the last 2 years, the president of the American branch of the International Law Association. And every year, we kick things off with the president's high-level plenary panel. And we're glad to see this room filled to the brim because you are in for a treat this evening. So, as president, it is my privilege to chair this opening panel. It is titled Powerless Law or Law for the Powerless, the Once and Future International Court of Justice. This past year, the International Court of Justice has issued groundbreaking decisions relating to the Gaza conflict and the status of Palestine, and it is poised to decide the momentous question of legal responsibility for climate change. Making law for the powerless, these cases have engendered praise and criticism, concern, and above all, worldwide scrutiny of the court's role and efficacy. In roundtable format, the president's opening plenary panel will be a high-level discussion of contemporary issues related to the World Court. For this roundtable, we've assembled a stellar group of experts. Now, the thing about speakers of this distinction is that everyone knows them so well, we can keep their introductions relatively short. So let me now introduce the panelists in alphabetical order, starting with Lori Damrosch. Lori is the Hamilton Fish Professor of International Law and Diplomacy at Columbia Law School, and she has written numerous books and articles about the International Court of Justice. She has served as the president of the American Society of International Law and co-editor-in-chief of the American Journal of International Law. Before joining Columbia, she practiced law with Sullivan and Cromwell and served in the office of the legal advisor of the U.S. Department of State. Next to Lori is Harold Hongju Ko. He is the Sterling Professor of International Law and former Dean of Yale Law School. He has served as legal advisor of the U.S. Department of State and as Assistant Secretary of State for Human Rights, Labor, and Democracy. Recently, Professor Ko represented Ukraine against Russia in 3 cases before the International Court of Justice and the Permanent Court of Arbitration. He has just published a new edition of his critically acclaimed book, The National Security Constitution in the 21st Century, which will be the focus of a separate ILW panel coming up. Next, we have Sean Murphy. Sean is the Minot Professor of International Law at George Washington University Law School. A past president of the American Society of International Law, Sean has served as a member of the United Nations International Law Commission, legal advisor to the U.S. Embassy in The Hague, and attorney advisor in the Office of the Legal Advisor of the U.S. Department of State. He has argued several cases before the International Court of Justice and the Iran-U.S. Claims Tribunal. He's frequently served as an arbitrator in interstate disputes, and he's even sat as an ad hoc judge on the International Tribunal for the Law of the Sea. And finally, we have Nilofer Oral. She's the director of the Center for International Law at the National University of Singapore and a member of the United Nations International Law Commission, where she serves as co-chair of its study group on sea level rise in relation to international law. She has served as a legal advisor to the Turkish Foreign Ministry for Law of the Sea and as a climate change negotiator. Now, I'm going to conduct this panel the way I do my Talking Foreign Policy radio show. As an aside, if you Google Michael Scharf Talking Foreign Policy, you can listen to the podcast version of my recent broadcast about foreign policy and the 2024 presidential election, which features a conversation with Harold Koh and John Bellinger, two former State Department legal advisors. Now, this roundtable panel ends at 7:15 sharp. The panelists will try to keep their answers short to save time at the end for questions from the audience, and then we invite you to go to the next room over where we have a wonderful reception hosted by my law school, Case Western Reserve. So let's begin with the questions for the panelists. For the first question, let's talk for a moment about the composition of the International Court of Justice bench. The 15 ICJ judges are elected for terms of 9 years on a staggered basis. Now, Sean, there was a time when habitually we saw a judge from each of the permanent 5 countries on the court. Now there is no Russian or UK judge. What are the implications of this development?
Well, thank you, Michael, for the introduction and for the invitation to be here. It's really a great pleasure, in particular, to be with the other colleagues on the panel who I admire quite a bit. It is good to start with the judges. When we think about the ICJ, it really is the judges who ultimately are the ones making the opinions that we read so closely. As many of you probably know, there's no requirement in the UN Charter or in the statute of the ICJ that the judges include members coming from the permanent 5 countries. So this is not like the UN Security Council. Even so, historically, there has been 5 judges from those countries on the court with just 3 exceptions. The reason why they have been there probably has been a sense of there being value in having those countries engaged in the work of the court. There's also just the comparative advantage that the permanent 5 members have, given that the judges are elected in a concurrent election. Both the Security Council and the General Assembly have to elect these judges, so those who are permanently on the Security Council have a bit of an advantage there. So the 3 exceptions have been, there was a gap in the period of 1967 to 1985 when there was no Chinese judge on the court. That was the time when we were seeing a transition from the government of China being based in Taiwan to it being based in Beijing, so there was a bit of an issue there. But the second exception was in 2017 when Judge Greenwood from the United Kingdom was not re-elected. People put that down to some extent to the effects of Brexit, also to the effects of the movement toward an advisory opinion on the Chagos Archipelago. The General Assembly had asked the question of the court about that just 6 months before the ICJ election. I will note in that context, it was somewhat important or interesting that the seat went to the Indian judge, Bandari, which meant that you did not have 5 judges coming from the WEOG, the Western Europe and Other group. You had 4 instead, and instead of 3 from Asia, you had 4 coming from Asia. So it had a consequence in terms of the regional representation. And then the third phenomenon or exception was the failure to elect the Russian judge, Gevorgyan, in 2023, likely some amount of blowback relating to Russia's actions in Ukraine. That particular seat stayed in Eastern Europe. Judge Orescu is from Eastern Europe, and so that didn't result in a regional reallocation. But your question, Michael, was what are the implications of this? I would say as a first principle, we should be looking for highly talented people to serve as judges on the court. And if you follow that principle, there shouldn't be any particular implications. The fact that you're from a P5 country or not shouldn't matter. As a second principle, though, I do think it is worth paying attention to having judges on the court from countries that do have some significance for engaging in the work of international law and the work of the court and so on. In that regard, I would note that switching from a UK judge to an Indian judge shouldn't make any difference. India is an incredibly important country. It's got the greatest population of any country in the world. So, you know, it's not obvious that there's a thing there, but not having a Chinese judge, if that were to happen, not having a US or UK judge, I think there's a significance in that lack of involvement. But I'll say this, and this is my final point, given that we're on radio, sort of. I do think that what's harmful to the court is if the voting for the judges is perceived as driven by global politics and not by the quality of the judges. And so, you know, if Judge Greenwood was seen as less capable than Judge Bandari, then so be it. If Judge Gevorgyan was seen as less qualified than Judge Orescu, then so be it. The chips fall where they will. But if something else is going on here, if it's something other than having to do with the quality of those judges, then I think over time it looks a bit politicized, and I think that's unfortunate for the court.
Okay, and I think that there's going to be a test of that in the next election because our colleague Dapo Akande, who will be speaking as part of International Law Weekend, it has been publicly announced that he is going to be the British candidate to the International Court of Justice. So we'll see. All right, this next question's for Harold. Let's discuss the ICJ's advisory opinions. Unlike the US federal courts, the ICJ can issue advisory opinions as well as judgments in contentious cases when it's requested to do so by an authorized international body. Within the last 30 years, advisory proceedings before the International Court of Justice have addressed some of the most controversial issues in international affairs, including the independence of Kosovo, the use of nuclear weapons, and the legality of the Israeli West Bank barrier. The pace of requests for advisory opinions has been accelerating. Among ICJ cases that have been active this year is an advisory opinion case related to state obligations in respect of climate change. And there's another one dealing with the legal consequences of the policies and practices of Israel in the occupied Palestinian territory. So, Harold Coe, do you think the ICJ advisory opinion process is somehow out of control? We'd be a little provocative here.
Well, I've been on 2 advisory opinion cases as counsel. One, the Kosovo advisory opinion, which I thought played an important and salutary role, and I'm currently counsel to for the international trade unions in the right to strike case, which we hope also will lead to a useful result. So I wouldn't say that I think that the process is inherently out of control. I would say, though, that the advisory opinion process is badly in need of 21st century management. So in addition to the things that Sean mentioned, all of which are correct, it's not just the quality of the judges, it's the nature of the institution. And the ICJ has an incredibly antiquated opinion writing process. It's extremely cumbersome. It makes it difficult for the judges to actually talk to each other about outcomes. In recent years, we've lost some of the strongest judges like James Crawford, who everybody knows. The questions that are put to advisory opinions are done in General Assembly resolutions, which can be extremely slanted politically. I mean, look at question 1 of the Palestinian occupation advisory opinion. Even if you agree with it, it wasn't worded in a way that you would expect in a normal legal question presented. There are too many oral arguments. The Palestinian occupation case was 6 days, 52 presentations, many of them, frankly, repetitive of the others. There's therefore a lack of focus. And when you put it together with other phenomena that you're going to mention here today, Michael, which is erga omnes contentious cases, intervention processes leading to 30 or 40, what's very clear is it's not dissimilar to when US federal courts suddenly realized they were dealing with aggregate litigation and didn't have adequate multi-district litigation or class action devices to manage them. And they're just going to need to do a better job of managing them, given that it used to be that being on the ICJ was a part-time job, and now they're being overwhelmed with work, and so they can't give all the cases equal attention. Finally, and this goes to something that both you and Sean said, in Dapo Akande, whose candidacy was announced today, we have an extraordinary candidate, really one of the best you could imagine, and I hope everybody here, whether you know him or not, learns about him and why he would be an extraordinary addition to the court. But now there is a 15 or 16-month campaign to get on the court. It involves hundreds of meetings, not just on live in New York, but live in the Capitol and on Zoom. Many of these meetings are subtle requests for knowing the judge's position, candidate's position on particular issues of concern to the government asking the questions. And it's just an inherently very political process. And so I think that, and it's an incredible gauntlet to have to run. Not everybody who could be a candidate can spare 16 or 18 months running a campaign and do their own job. So I think the advisory opinion process is badly in need of rethinking at an institutional level with these differences and exigencies in mind.
So I asked a provocative question, I got a provocative answer. Don't want to just let it sit out there. Are any of the other panelists interested in weighing in? Lori?
I'll weigh in on the questions that you're going to put to me later. Okay. That's okay. Yeah.
Sean or Nilofer? Sean?
Well, I'll just throw out another issue that I don't think Harold touched on, and that is that for some people, the advisory opinions sometimes are contentious cases in disguise. And because there's no jurisdiction in the contentious case, it goes into the advisory opinion process instead. So you certainly saw those arguments in the Kosovo advisory opinion, and I'll disclose I represented Kosovo in that case, that it really was a Serbia versus Kosovo dispute that should have been considered that and not an advisory opinion. Same with the Israeli wall and the recent Palestinian advisory opinion. It's really Israel versus Palestine. The arguments were also made in the context of the Chagos advisory opinion. It's really UK, Mauritius. Personally, I think those arguments aren't particularly strong because actually, if you're not a member state of the UN and you're not a party to the ICJ statute, you can't be sued or sue before the ICJ. Therefore, it's not really diverting it into a advisory opinion process. And the Chagos issue, I mean, clearly decolonization is something this General Assembly cared about for decades, still cares about. But I just raised that issue because it's entirely possible you could have a situation where there is jurisdiction between two states and it still goes into an advisory opinion process. And that's where I think the issue really comes to the fore. We, might see that at some point.
And just as an aside, Harold, you are a lawyer in a pending advisory opinion case on the right to strike. Why is that case important?
Well, that's a great advisory opinion case. For a couple of reasons. First of all, Sean is absolutely correct. There is no claim that the idea that in the ILO Convention 87, which has 158 states parties, there is a right to strike that was originally there at the ratification of the treaty. That's not a bilateral issue in disguise that should be addressed by a contentious case. And in the Chagos case, Joan Donahue, then the president, flagged this as a source of concern. So that's not a concern here. Secondly, this is an advisory opinion coming from a specialized UN agency, which is entitled to request it. Third, it is the first advisory request coming from the ILO to the International Court of Justice. There were 3 prior requests that were made to the Permanent Court of International Justice, all of which ruled in favor of broad freedom of association, extension of the jurisdiction of the conventions to various forms of labor, like agriculture and other kinds of things. So what had happened here was, I think there was, essentially universal consensus that ILO Convention 87 about freedom of association protected the rights of unions to strike. And that was shared by the tripartite group, the employers, the unions, and the states. And then in 2012, after over 100 years, the employers suddenly switched position and said, no, in fact, it doesn't cover a right to strike, and started to walk out of the ILO Council and do other kinds of things, until it got to the point that they couldn't do business in the ILO. And finally, the employees unions and the states decided that they would refer this to the ICJ for an advisory opinion. And the way the question is worded, is there a right to strike? All they're looking for is the answer, yes. And there always has been. Interestingly, of the 30 participants in the process, only 4 had said that for some reason there wasn't a right to strike. One of them was the UK. That brief or memorial was filed by the Rishi Sunak government, and then when Keir Starmer's government, which is called Labour, got elected, they withdrew it. And then, of course, the Joe Biden administration, Joe Biden walked on a picket line, so it would be quite unusual for him to say that there was no right to strike. So actually, part of the thinking in this is that the court now has very difficult advisory opinions. This is an easy one. All it has to do is say, yeah, it was a settled issue before they disrupted in 2012, answer the question, yes, there's a right to strike, and then there need not be another ILO case for the next 100 years. But I will point out this, and I think Sean would agree with this. Increasingly, there is briefing in ICJ memorials on advisory opinions about why the advisory opinion is admissible, because not every case is suited to be treated as an advisory opinion. And probably this court, after being overwhelmed with requests, will come up with some kind of Alexander Pekelian type jurisprudence about when these cases should not be reviewed on the merits in the name of certain passive virtues.
Yeah, well, we'll keep our eye out for the result in that case. Let me turn back to Nilofer. Small island states have initiated 2 advisory opinions in relation to climate change. In the recent ITLOS advisory opinion, that's the Law of the Sea Tribunal, brought by the Commission on Small Island States, over 30 states filed written statements. And in the pending request before the International Court of Justice, which was initiated by Vanuatu, a record-breaking 90 written statements were filed in the first round and over 60 in the second round. So, Nilofer, do you believe this reflects trust in the court or frustration with the political process on the part of the less powerful states?
Is it already on? Yes. Yes. Thank you so much, Michael, for the question. And may I say how wonderful it is to be here with such a distinguished panel and a wonderful audience on these very topical and important questions that you are asking us. Indeed, frustration or trust, I would answer both. So first of all, when we're looking at the plight of the small island states and climate change, it started many decades ago. In fact, climate change was first recognized as a common concern of humankind by an initiative by a small island state, Malta, in the General Assembly in 1988. 1989, the Male Declaration by small island states warning about global warming and sea level rise. 1990 started the first IPCC reports. Finally, we get the UNFCCC, the Framework Convention on Climate Change. But the political process has not really answered or responded adequately to the needs of the small island states, whether it be sea level rise, which is obviously the topic we're taking up in the International Law Commission, whether it be the other impacts of climate change, which are multiple, and also the needs of adaptation. We know the very controversial yet extremely important issue of loss and damage. I myself participated between 2009 and 2016 in the climate change conferences, and I can see the frustration. There's just nothing, I mean, there's a lot of talk, there's a lot of paper, but the small island states are still in a very adverse position, worsening. Clearly there's frustration, but to me what's remarkable is that they have looked to the courts, to international law. So it's not just simply the courts, it's a trust in international law where I see the other forum as a political forum more than a lawmaking forum, frankly. They have gone to the courts, and perhaps as well we can see that we mentioned the Chagos advisory opinion, and I'm sure that had a positive influence as well. And what is important, it's not just the small island states, but this was a case initiated by law students in Vanuatu. And so it's young law students who have apparently trust that the World Court, the ICJ, in the current one, but also ILWS was the Commission on Small Island States, and I have to say I'm a member of the expert committee. And there was a group of small island states who were also frustrated by the political system in the UNFCCC. And I think the outcome of that advisory opinion shows that they were right to trust ILWS. That was a very powerful opinion. It's an opinion, it's an interpretation, but it will have an impact. It has officially recognized greenhouse gas emissions as pollution. That means that many obligations, requirements will be triggered. That didn't come out of the political process. That has come out of the court. And there's much more to it. I won't summarize the whole case. So I would say frustration and trust.
How many of you out there are law students? Raise your hand. Okay, that's fantastic. Did you know that your fellow law students brought this important case? That's amazing. Let's talk about the court's contentious jurisdiction in relation to a spate of cases that have recently been brought under the compromissory clause of the Genocide Convention. So for some history, I'd like to turn to Lori. Lori, you first started studying the ICJ and the Genocide Convention back when the Cold War was the overriding feature of international politics. In the big picture, what are the main changes over time?
So thank you very much, Michael. And the reason that I didn't take you up on your invitation to answer the other questions is first, I largely agreed with what the previous ones had said, and second, maybe there'll be a little bit more to say that I'm hoping to put out there for all of you. So Genocide Convention was opened for signature and ratification in 1948, and at that time, it was the beginning of the Cold War, and the Soviet Union and Soviet bloc states were pretty hostile toward compulsory international dispute settlement. They thought that these new institutions, in some senses continuous from the League of Nations period, but being revived for the new era, would be biased in favor of the West and would be hostile toward the Soviet Union. So the Soviet Union joined the Genocide Convention, as did all of the Warsaw Pact states, but they did so with reservations addressed to the dispute settlement clause. And for those of you who are law students, if you have studied reservations to multilateral treaties, probably the first thing that you read is a 1951 advisory opinion of the ICJ. Now, this is a good use of the advisory opinion to get legal advice on a question that was new. Can states make reservations to dispute settlement clauses in a multilateral treaty? And the court answered that question basically saying, as long as the object and purpose of the convention, which is a humanitarian and civilizing purpose, is not impaired, then reservations could be permissible. And on that basis, the Soviet Union and the Soviet bloc states remained with these reservations for quite a long time. Now, the United States was a latecomer, and when it joined the convention in 1989, guess what? It followed the example of the Soviet Union and put in a dispute settlement clause, as well as other debilitating conditions to ratification. That was 1989, but good things started happening for international law as the Cold War was ending. And one of the good things was that the Soviet Union and the states of the former Warsaw Pact thought that they could enhance their reputation by accepting not only the verbal, rhetorical commitments of these human rights treaties, but also by accepting these institutional features, including dispute settlement. So the Soviet Union withdrew its reservation, and that meant that when the Soviet Union dissolved and Russia became the continuing state, it had no reservation to the dispute settlement clause under this treaty, and the same became true. Ukraine and Belarus had sort of special status in the period that we're talking about, but all of the successor states of the former Soviet Union becoming newly independent or reclaiming their independence, all joined the Genocide Convention without any of these reservations. So that's one sort of big picture change. What hasn't changed, of course, is that the United States and certain others are still clinging to this reservation to dispute settlement. Now, in parallel, we had other human rights treaties with similar reservations, and the Soviet Union and Soviet bloc states also withdrew their reservations, for example, to the dispute settlement clause of the Convention on the Elimination of Racial Discrimination. And so because of the withdrawal of these reservations, what you can see is that Ukraine can sue the Russian Federation. Georgia can sue the Russian Federation. Both of those are cases that could only exist because of the withdrawal of these reservations. Under the Convention on the Elimination of Racial Discrimination, that's the Georgian case, Ukraine versus Russia had both race discrimination and genocide contentious cases. And then under the Racial Discrimination Convention, we have Armenia and Azerbaijan having sued each other both under that convention. And that case, after going through provisional measures and various preliminary objections, is now fully heard and poised for decision. So, okay, so that's sort of the overall picture of the legal landscape under the Genocide Convention, and you're gonna toss me another question.
Let me ask you a follow-up. Right. So I think you explained why the Soviet former republics are now open for business under the Genocide Convention. Is that the only reason why we are seeing so many more cases now than in the past, or is there other things going on as well?
So yeah, I think that there are other things going on, and I also want to say that even though all of these reservations were withdrawn, it took a long time for any cases to get there. I mean, we had Bosnia-Herzegovina suing the Federal Republic of Yugoslavia, later Serbia, and we had Croatia suing Serbia. So you had those two cases under the Genocide Convention in the 90s. But you did not have a huge number of genocide cases being brought, nor under the CERD, nor under the Convention Against Torture. And all of a sudden, now, in the 21st century, we're getting them. And I have to say, just putting on my hat of the 1990s, in the early 1990s, the Human Rights Watch approached me and said, there's really interesting stuff in all of the documents of the Saddam Hussein regime that show that genocide had been committed against the Kurds of Iraq in the last days of the Iran-Iraq war. Do you think that we could find a state party to the Genocide Convention that might be willing to bring a claim against Iraq under that treaty? And I said, well, I could write a legal memo on that. And 30 years later, my legal arguments are finally being vindicated. But we did write a legal memo, and Human Rights Watch and several experts on the ICJ consulted with many, many governments. I won't say how many, but it was several dozen, and it includes several of the states that now are eagerly supporting human rights cases. And we could not find in the 1990s a single state that was willing to go out on a limb and say, we're prepared to bring a case against Iraq under the Genocide Convention. So I think that some of the factors that have changed include the legal landscape that I've tried to chart, both the withdrawal of the reservations and also the endorsement by the court itself in a notable case from 2012, I think it was, which Belgium brought against Senegal under the Torture Convention, in which the ICJ said that every state party to the Torture Convention has an interest in its enforcement and therefore can have standing to bring such a claim under the Latin term erga omnes partes. The obligations are owed toward all the parties to the treaty. Every state party to the treaty has a legal interest in its fulfillment. So with that case having been brought by Belgium against Senegal, involving the efforts to hold accountable the former dictator of Chad, who was then in residence in Senegal, and that kind of opened a door, and now many more states are walking through that door. So the Gambia, on a similar theory of erga omnes partes, brought suit against Myanmar under the Genocide Convention, and the court, in a 2022 ruling that's really quite path-breaking, endorsed fully this idea of erga omnes partes. So the other factors are more political, and I think that they do bear on some of the considerations that my colleagues on the panel were bringing up earlier. It just has to do with growing confidence that the court can be fair in these cases, and also that powerless states or relatively powerless states not only will get a fair hearing, but that they'll draw attention to a very valid, very worthy cause and can do so through the initiation of such suits. And they wouldn't do so if they didn't think that they would be vindicated in the court of public opinion, even if their adversary may flout the judgment later on.
And Harold wants to weigh in on this. Go ahead, Harold.
Well, I agree with what Laurie says, but two quick points. One reason for more cases is just that some states are ready now to fight and litigate at the same time, which sometimes didn't used to be the case. You know, the US contested jurisdiction in the Nicaragua case, contentious case, and lost, and then it walked. But we now have a situation where, you know, Russia is both daily using military force in and against Ukraine and litigating at the ICJ, the Permanent Court of Arbitration, and the Law of the Sea Tribunal. Their lawyers quit, and so they hired new lawyers who, I mean, you can imagine the kind of argument those guys are making. But you know, Iran, for example, is amazingly litigious with regard, you know, they filed the affirmative suits against Canada about their immunity laws, et cetera. even while they are obviously actively supporting various forms of militias. So I think that this actually creates some severe complications. One, what do you do when the president of the ICJ is from Lebanon and Israel is firing bombs into Lebanon? Does that create a complication in terms of whether people think that that judge is fair? In South Africa, they claim to be an erga omnes representative because they analogize their situation to apartheid as they feel that the Palestinians are experiencing. But then when Bashir comes to South Africa, subject to an ICC arrest warrant, they don't arrest him. So it may well be that the erga omnes test is not giving enough of a texture requiring some consistency of behavior in these cases, and I think that that's something that the court should be looking out for, as well as those of us who are discerning international lawyers.
I'm just watching Lori's body language. Do you want to rebut?
Well, so I agree with some of what Harold said, but there's enough disagreement there. So I think we don't know yet what pleadings are going to be coming to the ICJ that may raise questions about whether a judge from Lebanon can fairly preside over the case. But I have to say that we have had presidents of the court who are also coming from states that are litigants before the court, and they take the appropriate decisions, or they have, or they could. And I don't think there's any reason to predict in advance that a certain judge might have his or her objectivity questioned and wouldn't know how to deal with a challenge of that sort if it came. So I for my own part, I would like to indulge the presumption that the members of the court are well qualified and capable of acting independently and impartially and capable of taking the appropriate decisions if there's some reason why they should not exercise certain functions, whether of a judge or of a president or of a vice president, as the case may be in a particular case. So I have to stand up for the honor of the court, because I really think it's a mistake for lawyers or law students to start with an assumption that a judge is going to be biased. I just,
So
we saw that with the South China Sea. You know, we've seen it with attacks that come from people who are not knowledgeable about the court.
Leaving that question
Can
aside.
I just say,
Oh, go ahead. I guess we're not going to leave it aside. Harold, go ahead.
come on, Laurie. Come on. I mean,
Come on. Okay.
I mean, obviously there are some judges who are scrupulously fair, and there are some judges from certain countries who have traditionally not been impartial. And I think everybody knows that. Everybody who appears before the court knows that. And there is not a good process for fleshing out bases for recusal when someone's impartial. But by the way, we don't have a particularly good process at the US Supreme Court either, as you may have noticed.
Right.
But what it does do in both cases is to cast doubt on the impartiality of rulings, and I think that that's an unfortunate situation. And you know, I think that I'm not saying that students should start with a presumption that a judge is biased, but I think they should also ask, you know, sometimes it may be that a judge decides that they're not the appropriate person to sit in a particular case because of the appearance of impropriety, which is what judges are supposed to do in courts everywhere.
All right, so that issue aside, what you were saying, Lori, about all these new cases, starting with the torture case, to understand how radically different that is than the old precedent at the ICJ, I want to ask Sean a follow-up, and that is, Sean, in the Southwest Africa cases back in 1966, the ICJ said, quote, an actio popularis, or right resident in any member of a community to take legal action in vindication of a public interest, is not known to international law as it stands at present. So in light of the recent ICJ jurisprudence, Sean, would you say that that statement is no longer a true statement? Or is there a way to distinguish it somehow?
Well, first of all, I feel like we should have more sparks going on this side of the room.
Sure.
We're letting you down a little bit, maybe. So just to remind folks, particularly the students maybe aren't overly familiar with the Southwest Africa cases, but they were decided in 1966. And what that involved was two countries, Ethiopia and Liberia, bringing a case against South Africa, which was the sort of trustee for Southwest Africa. It's now, of course, Angola, but at that time was under the sort of mandate left over from the League of Nations, where South Africa is supposed to be looking out for Southwest Africa. And yet it appeared South Africa was implementing measures that looked a lot like apartheid in Southwest Africa. So Liberia and Ethiopia bring a cases against South Africa, and is confronted with a South African argument that they don't have essentially any standing. There's not nationals from their countries who are being harmed by this. And the court, in a very close vote, in fact, it was a tie vote that the president had to resolve by voting twice, decided that, in fact, South Africa was right. These two countries did not have standing to bring the case, and that's where this Actio Popularis quote that you gave us, Michael, came from. The court was highly criticized, even at that time, for the decision, and I think over time the feeling has been it was a bad decision, and even then it was a close decision. So why was the court in that place? Well, I think it's still relatively early in the life of the court. You've got a strong sense of state sovereignty operating. The human rights movement hadn't fully flowered at that point. And I think the court was just being very cautious about how it proceeded. So to answer your question, no, I think it's in a very different place today. I think the court is now much more open to at least the concept of erga omnes partes cases, meaning cases like Lori was talking about, where you've got two countries that are both parties to a particular convention, and one is suing the other, even though the one that's bringing the case isn't being directly harmed. I think we are seeing the court very open to those types of cases, at least when it comes to something like the Genocide Convention. Maybe I'll just give you a little quote of my own. This one's from the Gambia versus Myanmar case that Lori, I think, alluded to. The court said, all the states parties to the Genocide Convention, all the parties, have a common interest to ensure the prevention, suppression, and punishment of genocide by committing themselves to fulfilling the obligations in the convention. Such a common interest implies that the obligations in question are owed by any state party to all other states parties to the relevant convention. They are obligations erga omnes partes, in the sense that each state party has an interest in compliance with them in any given case. And from that flowed the idea that you could, in fact, have the Gambia bring a case against Myanmar, even though there were not Gambian nationals being harmed in the context of the alleged genocide against the Rohingya. So it seems like this issue of do they have an interest is being answered yes in the context of a multilateral treaty where a claim is being brought. What we don't know yet is the breadth of that, I think. It's certainly true for the Genocide Convention. It certainly seems to be true for the Torture Convention, as Lori mentioned in Senegal, Belgium-Senegal case that was in play. And so these core human rights, multilateral human rights treaties, it may well be the case that this erga omnes partes thing is operating.
Let me ask you, Sean or Nilofer, do you think that the Law of the Sea Treaty could be subject to erga omnes partes litigation?
I feel we have to disagree on this to get those sparks going. But it's a great question, because certainly, if you don't mind, I'll just
start it out,
embellish a little bit, and then the core human rights treaties seems to me are certainly in play. Not as obvious other treaties where there's a common interest. Certainly when you get the Law of the Sea Convention on the high seas, you've got a common interest Antarctic Treaty, outer space treaties. Maybe it expands to cover that. Does it expand to cover all multilateral treaties? Not obvious to me, at least. When you think about the Barcelona Traction, where this idea of erga omnes obligations was sort of birthed, the court seemed to be saying trade, investment, those kinds of things aren't in play. It's these, more aggression, genocide, and whatnot. So a distinction is certainly being made, and I don't think we know exactly where the line's being drawn.
Leila, what do you think about the Law of the Sea Convention?
I'm sorry, no sparks, because I think I may agree with, in terms of, first of all, of course, UNCLOS is a big convention, over 300 articles, but it would be more on those concerned protection of the environment in particular, and they're the high seas. And ILWS has already said that protection and preservation of the marine environment is an obligation, erga omnes. And we actually saw that, but although never mentioned it that way, in the South China Sea case, which was very interesting. So I would say that for the Law of the Sea Convention, it depends which part, not all of it, of course.
Okay. Let me go back to Harold. Harold, you mentioned the Ukraine case against Russia and the Genocide Convention. What do you think is the best that Ukraine could hope to achieve out of the merits in the proceedings in the upcoming Genocide Convention case?
Let me just preface my remarks by saying that I've known Lori for 40 years now. She first met my...
You don't want to start in on the genealogy. That would take us for the rest of the time.
She first met my brother 54 years ago. So I think that our relationship will survive this point of disagreement. But the important thing about the genocide allegations case, and this is a warning to the students, the international log blogs and Twitter are great. If you read the opinion and see whether you agree with what the blogs have to say, and I don't think there's any case in which I've read more bad blogging and more bad X or Twitter or whatever than, I mean, literally people were so determined to get out their instant analysis that they missed many of the key holdings in the court's ruling. But first of all, the prime accomplishment of the genocide allegations case is that people thought that the only way a state could sue another state was if that state committed genocide. And it turns out that what Russia is very good at doing is claiming that other states have falsely claiming that other states have committed genocide as a basis for invasion and as justifying naked aggression and then atrocities. And so one of the things we said is this is a question of interpretation and application of the Genocide Convention that would allow neighboring states to bring these claims. And that if they couldn't bring these claims, then they would be next. Because if Russia can use false claims against Ukraine, calling them neo-Nazis, et cetera, to invade and engage in a massive multi-year war causing billions of dollars of destruction, Poland is next, Moldova is next. And indeed, this is not a legal point. This is the exact point that Kamala Harris made to Trump in the debate, which he appeared not to understand. Now, the way that the court recognizes these other interests is by allowing intervention under Article 62 and 63 of the statute of the ICJ, and those distinguish between those issues in which there's an interest of a legal nature, which is what Poland has invoked as a basis for intervening on the merits, and then 31 other countries have invoked Article 63 intervention, which is that they are parties to the same convention, so have an interest in the convention not being wildly misconstrued. So we also have a situation in which the court, by a vote of 12-3, issued a provisional measures order less than a month after the invasion began in March 2022, where they said that Russia should remove its troops and paramilitaries from the territory of Ukraine. and they have been in blatant violation of that ever since. Now, in the most recent decision, Ukraine versus Russia on the financing of terrorism and the racial discrimination case, they said that violations of the provisional measures order end up being compensable whether or not they end up finding a ruling in favor of them on the merits. So when you add it all up, what the answer to your question, Michael, is obviously declaratory relief and orders of non-repetition, but there is a very strong claim of reparations because they've been in blatant violation of these orders. And there are 365 billion euro in frozen Russian assets. And right now, those are subject nominally to the idea that they're in the title of the Russian Federation. And the allied governments and many European countries have been hesitant about allowing these assets to be seized because of their concerns about overuse of countermeasures or sovereign immunity. And when you think about it, how comical is it that they believe that Putin, having so blatantly violated the sovereignty of his neighbors, is allowed to invoke sovereign immunity as a basis for not being able to pursue his assets. What everybody agrees, though, is that the strongest case for post-judgment execution attachment is based on a merits ruling of the ICJ. And so that's there. The Europeans have just started to, under pressure from Secretary of the Treasury Yellen and others, open the door for some of those assets and the interest on those assets to be turned over to the Ukrainians as a basis for reconstruction. So this is a long struggle, but the whole point of legal argument is to change people's notion of the legitimacy of certain kinds of claims of political and economic necessity, which are clearly being made here.
So sometimes we wonder about the effectiveness of the ICJ's decisions, and you are explaining how, in terms of this huge amount of frozen assets, there is a really concrete potential effect. I want to turn to Sean about provisional measures, because Harold also mentioned the use of provisional measures, and for you law students, it's sort of like a TRO in US jurisprudence. Sean, we sometimes see more than one country at a time asking for provisional measures. Is the court well positioned to issue such orders?
So we are seeing a lot more requests for provisional measures from the court. In fact, I went back and looked at the basic numbers. In the first 50 years of the court's existence, that's up until 1996, with the Brayard case, the court was deciding requests in just 19 cases. So that's roughly 0.4 cases per year, if you will. In the ensuing years, 1996 to the present, you've had those requests made in 39 cases, which is about 1.4 cases per year. And if we take just since 2020, the past 4 years, the court has decided requests in 10 cases, that's 2.5 cases per year. So you're seeing it increase, not exponentially, but increase significantly in recent years. Moreover, within cases, you're seeing multiple requests being made. So Harold was just talking about the Ukraine-Russia case. Harold was not talking about the South Africa-Israel case, but just this year, we've had provisional measure requests in January, March, and May decided. And in the Azerbaijan-Armenia cases, again, I'll divulge on my counsel, requests in just the Armenia versus Azerbaijan case being decided in December of 21, October of 22, February of 23, July of 23, and November of 23. So we are seeing a huge increase, and this goes to your question, is the court well positioned to decide this? So far, I think it is coping, but it's putting a pretty big stress on the court. Under the court's rules, Article 74, Para 1, they have to decide a request for the indication of provisional measures with priority over all other measures. So basically, they have to kind of push aside what they're doing and schedule a hearing and get everybody into The Hague within a matter of 2 or 3 weeks to, and then issue the order, which sometimes can be quite long. So we are seeing that happening quite a bit, and it is imposing a burden on the court, but they're coping. And moreover, they took a decision in 2020. They adopted a new article in what's called the resolution concerning the internal judicial practice of the court, where they are now within the court establishing an ad hoc committee that looks at these provisional measures orders that have been issued and looks at reports that have been requested from the states who the measures are against. And the committee is supposed to examine the information and report periodically to the court about whether or not there's compliance and to recommend potential options if there's an issue. Of course, the court as a whole has to take the decision, but that too is a bit of a burden on the court. So yes, I think the court is coping, but I think it's pushing their limits a little bit.
All right, so these modern genocide cases have not yet fully gone to the merits. We've seen these provisional measures decisions, though. I want to go back to Lori and ask, have those provisional measures decisions had any effects in terms of changing the behavior in ongoing armed conflicts?
Well, I want to say that the short answer is going to be a qualified no, because if you look at the notorious cases, and I'll start with one that's not a genocide convention case, but it's the case that Nicaragua brought against the United States in 1984, alleging violations of the customary international law prohibition on the use of force, and there was a provisional measures order, and the United States said, we're paying no attention to this, and then there was a final judgment, and with the final judgment, on the very day that the judgment came down, Congress approved something like $100 million for the very program that the court had ruled to be unlawful. So that's not a genocide convention case, but then when you look at the ones from the 1990s, the Yugoslavia cases with Bosnia versus Serbia, there were provisional measures there. Did it affect the conflict? No. And the case went on for 14 years before there finally was a judgment, and you'd be hard-pressed, I think, to discern any real-world effects from provisional measures. So when we get to the current period, and we have both the Ukraine versus Russia, and now South Africa versus Israel with a sort of escalating series, as Sean has pointed out. When I want to say it's not just a flat out no, but a qualified doubt, if you were going to try to, what's the best case that you can make that there's been some effect somehow? First of all, I do agree with my learned colleague here, Harold. We've been twinned for so long. How can we disagree on anything, right? I do agree that even a provisional measures order lays the groundwork for other states to take sanctions of some sort, and lays the groundwork eventually for reparations being awarded and enforced later on. So that's why it's not a flat out no that Russia is totally disregarding this, because it could have some effects, among other things, on third state behavior in respect of their willingness to freeze assets or maybe eventually apply them, as we're seeing creative efforts to do. Now, South Africa versus Israel is a more complicated case, with these multiple orders coming down in succession, 3 in the first few months of this year. And the reason I want to say that there's a possible mixed picture here. I mean, if what we see is, has Israel changed its military strategy in the big picture? And the answer most likely is no, but I think there is some incremental effect that comes from the discipline of having to have lawyers go to the court and say, here's what we are doing, here are the ways in which we are trying to minimize casualties, or we are trying to ensure delivery of humanitarian aid. And I know it's going to be a difficult sell, but I think it's a more than negligible effect that comes from that requirement, a legal requirement, to make those statements in court and to be held to account for complying with them.
Harold, what do you want to add to that?
Two quick points. When we won the provisional measures order for Ukraine in the genocide allegations case, I got a call from an American reporter whose first question to me is, isn't this a meaningless ruling? Because the ICJ can't enforce its own rulings. And I said, excuse me, no court anywhere in the world can enforce its own rulings. Did you ever read a case called Marbury versus Madison? You know, it's the province of the duty of the judicial department to say what the law is. And then once it says that certain actions are illegal, everybody is then authorized to enforce it and to isolate the legal violator. And I said to him, how do you know? I said, you believe that what the Russians are doing is illegal? And he said, yes. And I said, how do you know? And he said, well, there's the, resolution, the General Assembly, and there's all this other stuff. And they finally said, well, there's this order of the International Court of Justice. And so in other words, it is a declaration of a norm, but it's a form of complex enforcement, not simple enforcement as you have in a domestic system. So when Lori mentioned Daniel Patrick Moynihan, a former senator, embodies compliance with the provisional measures order into a U.S. statute. And then Abe Chase, the lawyer for the U.S., for Nicaragua, said, we just got our provisional measures from Congress. So that's one way that it can happen. But the other aspect of this, which I think was just referred to by Sean, is it places a burden on the court to be even-handed. If they're issuing 3 consecutive provisional measures orders against Israel, and they're ignoring blatant violations of provisional measures orders by Russia, are they actually fulfilling their role in issuing these provisional measures orders? Now they have this committee. Nobody's actually seen what the outcome of this committee is. But you all know from taking first-year civil procedure that when a court issues a structural injunction to a prison or a school system or a hospital that's unconstitutional, it then bears the burden of trying to monitor whether it's actually meeting those standards. And when it does that, people start saying that the court is exceeding its assigned role in a system of governance. So I think that is the complication.
Okay, I'm going to use that as a segue to our last question for a panelist, and then we're going to open it up for about 20 minutes for audience Q&A. While I'm asking this question, if someone wouldn't mind taking the microphones over there and repositioning them in the middle and in the side so that we can have people who want to ask questions stand behind the microphone. So my last question is for Nilofer. Let's discuss the big picture as it relates to the theme of International Law Weekend. So has the ICJ become the forum for the powerless, as demonstrated by the surge in cases, including filing of interventions by states, by the less powerless states against the powerful, for example, Ukraine, the Gambia for the Rohingya, and Palestine, Vanuatu, as you mentioned, for climate change. So Nilofer, what does this mean for the future of the ICJ?
Thank you, and thank you for giving me the last question. So I should say that I have the great privilege of living and working in Singapore. And Singapore is a very small state. And Lucy Reed is here, and she knows, very small state. And they will always say that for them, international law as a small state is absolutely existential. And it stems from the notion, the absolutely essential principle of the sovereign equality of states. But we know in reality, in certain form, that isn't always the case in the UN, the Security Council. And so I think what we see, and Professor Douglas Guilfoyle has actually written about this recently, about small statecraft and litigation and going to the courts. In his case, he was looking specifically at ILWs. So it is clear that the number of cases that have been going to the ICJ, but also ILWs as well, because the Commission on Small Island States brought their advisory opinion, but we also know that other states have used ILWs to bring their grievances. So absolutely, the International Court of Justice, and again, we go back to, it's not the only one, but it certainly is an important one, Chagos. But many other cases now where I think going back, and I also agree with Lori, hoping that the integrity of the judges, and that is why they're going to a court, an international court, where the sovereign equality of states, where the defendants on both sides will be respected. So I think it is an absolute reflection that the small states are looking to the International Court of Justice and also other courts as well, and tribunals, to assert claims that otherwise, going back to the issue between international law and international political fora, that they would not be able to have the same equality of voice, of influence, and that. However, having said that, I will say this, though. I would like to see, though, that the representation of small states and the less powerful states also be by counsel from those states as well. And this is why I'm going to add something about advisory opinions. And just on this point, there is an important, what we've seen through the advisory opinions and also through the interventions, and as we said, 60, whether it be an IT loss, then it was about 30 states. We'll see probably, I don't know how many in the advisory opinion that's before the ICJ, but it has really opened up for representation before the ICJ, before international tribunals, for others. Not everyone has the great opportunity and privilege to go before these, eminent, the ICJ, but it has given that opportunity. So I see that as something very positive. And so it's not just small states taking their claims, but also the less powerful states and their counsel having an opportunity as well.
Thank you. That was a wonderful way to conclude the panel part. Now we have 20 minutes for the questions from the audience. And I remember when I was in the audience at this presidential panel that I always thought that was the coolest part, because you can ask the panelists the questions now. So we have a microphone here. I think that's, oh, and there's one there. So please don't hesitate, come on up. And here's what I'd love you to do. State your name, state who your question is for, ask a question, don't make a speech, and keep it short. So the microphone is yours. Come on up. Hey, do we have audio in the microphone? It's glowing. I think that's a yes. No.
This one does.
Okay, let's try this one then. Thank you. Houston, you're a lifesaver.
Thank you. Well, thank you for that insightful conversation about many themes. I found, my name is Mario Sáenz, I'm from Peru. I found very interesting, and my question is mainly directed to Professors Murphy and Urwal. I found very interesting the discussion about the multilateral treaties and regarding erga omnes rules. But regarding genocide and torture, I would believe that the discussion would translate more regarding jus cogens norms. And that's why regarding the Law of the Sea Convention, you have sustainability and sharing of benefits. Those aren't really jus cogens norms. There's a short list of the ILC put out just recently in 2022. I'm not going to elaborate on that because you already know that. So my question would be, what's your opinion on this? Because, of course, the erga omnes discussion is very important but shouldn't be redirected to these imperative rules of international law. Thank you.
The two of you?
So we mostly talked about, in the course of the panel discussion, the erga omnes partes concept, where you've got two states that are both parties to a multilateral treaty, and that seems to have flowered. Where I think you're taking us is, let's assume you didn't have a treaty. You had two states, and you could get jurisdiction before the court on some basis. Let's say it's Article 36, Paragraph 2, compulsory jurisdiction, but there's no treaty between the two states, and the claim is based on something like a jus cogens violation.
Sean, I think his question actually, and you can correct us, I think he's saying he wants to put the erga omnes back in erga omnes parties, because so far all the erga omnes parties cases have involved those traditional erga omnes issues of torture and genocide, and he wonders if they should be confined to that no matter what the treaty is.
Okay, so one possibility, I think we talked about how we don't know the exact scope of erga omnes parties, and one possibility is it's limited to that relatively narrow band of significant human rights violations that might be said to be the jus cogens norms. Now, jus cogens, most people think also include violations of charter use of force rules, so it's not just the human rights domain, but that's one possibility. I guess I was just trying to extend it to say, if we drop out of the treaty scenario, and we're talking instead about a customary international law scenario, is that where we would see it confined to an jus cogens type situation, as opposed to other forms of customary international law, in which all states may be interested in one respect or another.
Niloufer, did you want to add anything? No? Go ahead.
No, just simply saying, I think it's interesting because you brought the question because of the Law of the Sea Convention, comparing that the genocide and the torture reflected jus cogens norms, but in the Law of the Sea Convention, that was not the case, yet erga omnes does apply to parts, at least we know, for the high seas and protection of the marine environment. Is that correct? Yeah. But it's interesting, jus cogens is also an evolving concept. And when we did the work in the commission on peremptory norms, there was a list, but that list was a list of jus cogens norms that had been recognized in the past by the commission, but leaving it open for the evolution. So who knows what happens with certain parts of the Law of the Sea Convention, especially concerning the marine environment. So I'll just say that much.
All right, well, we have 3 people in line, and if you'd like to come and join the line, that would be wonderful. Next.
Hi, my name is Eleanor. I'm an LLM student at the Fletcher School at Tufts University. My question, I guess, is for whoever feels qualified to answer it. So in thinking about recent advisory opinions, it seems like there's been somewhat of a resurgence of issues related to decolonization, particularly with the Chagos decision, and then with the recent OPT advisory opinion. And I'm wondering if any of you think that those cases might have any effect on future litigation concerning territories like Western Sahara or West Papua or other territories that maybe were not fully decolonized by some accounts, and whether those cases will have any bearing on those situations.
Great question. Who wants it? Harold.
I think that some of these cases are pushing the court to the limit of its political awareness. You know, the Palestinian occupation advisory opinion says Israel should immediately withdraw. And also secondly, that very little mention made of the Security Council framework in 242 and 338. Many of the arguments that were being made to a UN court were ignoring the governing UN framework for addressing this issue through negotiations. And Judge Nolta and Judge Cleveland, in their separate opinion, had a good question, which is, if they withdraw immediately, who's going to fill that gap? You know, for example, in Gaza, who would fill the gap? Hamas? the Palestinian Authority is not strong enough. You know, you have Biden is pushing forward now a plan in the wake of the death of Sinwar where he's hoping to actually revive and strengthen the Palestinian Authority so they can be an alternative solution. So simply, you know, the Chagos case is a fairly straightforward case where you give something back. But when you have a situation which is so complex and complicated and so historically riven as the situation in the occupied territories, there has to be some awareness of exactly whether the outcome being pushed for by the court is actually going to help and lead to a durable long-term solution where people can negotiate in good faith to create a new alternative to the Oslo Accords. And that was not, you know, obviously that's not part of the legal question, and the judges are not supposed to be negotiators, but they also cannot recommend something that, if followed, is going to lead to all the houses, the whole house of cards coming down.
Okay. All right, so we have 10 minutes left. There's 5 people in line. Let's do this. Everybody ask your question in a row, and then we'll have the speakers address the questions that they have time to address. Go ahead.
Thank you. Hi, everyone. I'm Dominic from Indonesia, and I'm currently the LLM student in Harvard Law School. I have 2 questions. I'll make it short. The first one,
keep it to 1.
Yeah. Okay. The first one is basically the different interpretation between the responsibilities or obligations of third states that I observed from the Namibia advisory opinion, and then the Wall advisory opinion, and then the latest advisory opinion on OPT. Do you think what might motivate the court to have those different interpretations for third states? Because in the last OPT advisory opinion, the court instead give the UNSC and the UNGA to basically implement and interpret such obligations. So I think that's my question. Thank you.
All right, we've written that down. Next question.
Hi, I'm Steven. I'm a student from Boston University. I have a question for Professor Koh. You said that ICJ provisional measures and such things are not meaningless because, at least in part, they constitute an expression of a norm. And I agree with that, but how meaningful can this norm expression actually be in the absence of state practice? And how can the global community promote state practice based on these norms?
Thank you, Stephen. Next question.
Hi, my name is Tanya Agrawal. I'm an LLM student at George Washington University, and my question is for Professor Sean and Professor Nilofer. So with the rising in sea level and climate change issues, ICJ has already came out with doctrines on continental shelf, with the North Continental Sea Shelf cases and other cases. So what do you think will happen if the rise in sea level happens with the shelf? The doctrines will change, or will the ICJ has to come out with new doctrines or new legal points to again redefine how it'll be set up for the new changes, to adapt to the new changes? Thank you.
Interesting that happens to be this year's Jessup International Law Moot Court question. Next.
Hello, sir. I am Ahmed advocate from Pakistan. My question is that International Court of Justice decides some cases, but there is no implementation. As in common law, as in common system, legal system, we see, and there is an executor. Court decide and orders to the for execution. My question is, International Court of Justice decides, and who execute these decisions? For the states, for powerless, or for the powerful?
Thank you. That's a great question, and the last one we have.
Thank you so much. So I am Susan Ann Samuel from University of Leeds. I'm a PhD candidate. So my question is to the entire panel. Anybody can answer. It's just that who or what determines whether a law is powerful or powerless in the pursuit of justice? Because I'm thinking of human rights, for instance. The whole concept has the overarching natural law or the use-scopings, but when it comes to negotiations or climate or things like that, it just doesn't happen. And it has been a real big measure in 2015 with the Paris Agreement. But human rights kind of like is driving an entire new landscape with global North-South solidarity and international cooperation. So thank you.
All right, so Dominique, Stephen, Vanya, Amal, and Susan, thank you for being part of this. We're just gonna go down the panel from Nulifer in reverse alphabetical order, if that's all right. Don't mean to put you on the spot. Respond to any of the questions you feel like it, and we just have 7 minutes left.
Okay,
So.
very quickly, I guess the question from our dear colleague from Indonesia, as I understood it, was what the potential impact of sea level rise and continental shelf, but basically I think it's the maritime areas she's asking about. So this is something, of course, we're studying in the International Law Commission, but I will say this, there was an interesting case, Bangladesh versus India, where Bangladesh raised the issue of future impacts of climate change and sea level rise, and how that could impact the boundary. And the arbitral tribunal said there that they would look at the present time, not the future, and therefore that would not impact their decision. So, but it's a big question, so I'm going to just stop here, and I'm sure Sean can add to that.
All right, so Sean, any other questions you may address?
So I think we already answered Eleanor's question, but I would just note that there was a 1975 advisory opinion on Western Sahara, so we've got one there already, and it's well worth revisiting on issues such as self-determination and whatnot. So one question was on the rising sea levels and the effect on things like the continental shelf regime. As you probably know, there's been a lot of development, and the ILC's been looking at it in terms of allowing states to freeze essentially their baselines, even if the coast is regressing due to rising sea levels from climate change. And that may develop over time as a customary rule of some sort. The question really was about delimitation issues. Certainly, if you've already delimited your continental shelf, I think generally it's understood that that line should stay where it is. Where it gets a little bit more tricky is if there's in the future going to be a delimitation and you don't yet have a line, and what base points should be chosen for purposes of developing that line. I don't think we know the answer to that yet. If you are allowed to freeze your baselines, then presumably the base points should freeze as well, and that should allow you to eventually develop a delimitation. But I do think that's an area where there's some outstanding issues that need to be sorted through, and no doubt an institution like the court will help us with it. There was a question about essentially enforcement of ICJ decisions, I think. Obviously, in the charter, the idea is go to the Security Council and hope that they might help. That doesn't answer the powerful, less powerful state aspect of the question, which is fair enough. I guess I'd just say that it's rather remarkable how much compliance there is to ICJ decisions, and how much they can affect states, even powerful states. And here I'm thinking about the United States and the Nicaragua v. US case, where ultimately it had a tremendous effect on the way Congress viewed what was going on. The Reagan administration was able to do what it wanted to do. I think it's very significant. Harold at times talks about the conveyor belt between international law and national law, and I think you do see that in the context of these ICJ decisions. Having said that, there are clearly limits. They will not always result in a particularly powerful state backing off, but I like to think that, you know, that's on the margins of what we're talking about with this system, and it's probably true in national systems as well in many instances. So I try not to get too discouraged about that. Last thought, law, the power of law and climate change. The court can only do so much, right? The court's not going to solve the climate change problem. It's a part of the tools that one tries to deploy. But on something like climate change, we need countries to come together on that. That's the way we're going to solve it. And I think courts is just one part of the story in bringing about that solution.
Okay, Harold.
There's a common element running through the question that Stephen asked and that Susan asked and that our friend from Pakistan about enforcement asked, which is, you put it well, Susan, what determines whether international law is powerful? You do. We all do. The international community does. My brother's a doctor. He's a cancer specialist. And we were watching television, and someone comes on and says, international law has failed. Why? Because Ukraine has been invaded by Russia and because there's war in the Middle East. And he said, that's ridiculous. If someone comes into my examining room and says, I have cancer, so medicine has failed, that's the beginning of the inquiry. The question is, what do you now do? You have tools, and none of the tools is guaranteed to work, but it's a question of skill, craft, will, ingenuity, persistence, formulating a strategy that's going to work, getting the kinds of treatments that are going to be effective, and bringing them all to bear in a way that solves the problem. And one of them, and one of these aspects, is a provisional measures ruling if it's going to make a difference. If you want to keep China out of an open alliance with Russia, have them be declared in violation of international law, and then that will chill out China for a while. So I think the whole point here is that this group of individuals are actors in this process. You know, you're not just watching some mechanical process unfold. The question is, do we do it right? Will the lawyers bring good cases? Will the ICJ show wisdom and leadership? Will the court be prudent and not exceed its bounds? Will it modernize and address the complicated set of issues that are to come? Will it tailor rulings in such a way that sustain and enforce durable political solutions? Then international law can make a positive difference. If one of these things goes wrong, and because they've failed to take that opportunity, then you can say that the international lawyers failed, not that international law itself has failed. So it's a challenge. It's not a scientific question. It's a challenge for all of us in this room. Are you doing what you need to do?
Lori, you get the final word.
Right, I feel like the only thing I should do now is just sing, but because I really do, I want to applaud everything that my colleague has said. We really are soulmates. We do think very much alike. So I think that there was a number of the questions had to do with the relative effects of advisory opinions, final judgments of the court, and then these provisional measures orders. And I want to underscore what Sean had said, which is that when you look at compliance with final judgments, the ICJ compliance record is actually very high, very good. It's something like 95% of final judgments are complied with, at least given enough time, and the exceptions when a final judgment is not complied with are truly rare. Now, advisory opinions, so advisory opinions are advisory to the requesting organ. They are not binding except in a certain narrow little category that's not the type that we're talking about here. And so the Western Sahara advisory opinion, which was mentioned, the addressee is the General Assembly. The court's not going to go back and give a different answer. And so, you know, what can the General Assembly do after a half a century of non-compliance with that advisory opinion? Well, that's more of a political rather than a legal problem at this point. On the provisional measures, the record there of compliance is more mixed, and it's all kind of garbled because up until about 25 years ago now, nobody really knew whether provisional measures orders were binding or not. The court said in a case in which the United States was the addressee of such an order that yes, they are binding, and it has later said and affirmed many times now that as Harold has said, the violation of a provisional measures order is itself an independent legal wrong for which reparation can be demanded and ordered. And so there are many reasons why the compliance record with provisional measures orders has been so variable, and part of it is when these orders come down in the middle of an armed conflict and a state actually probably is not going to change its military policy outright because 15 judges in The Hague have said that their strategy is in some sense not compliant with an international obligation. So I think we should go back, though, to the ringing words of my colleague, Professor Coe here, that what we're going to do with the tools that we have really does depend on everyone in this room. And advisory opinions, even if they don't have direct binding effects, they can be used to mobilize public opinion. Provisional measures orders, even if there's not going to be compliance right away, they can help mobilize public opinion in many different arenas for alternative techniques. And then final judgments, I think we have a pretty good record that we can stand on, and I'll be proud to claim it. So,
Okay,
thank
well,
you.
what a way to kick off International Law Weekend 2024. Will you all please join me in thanking our wonderful panelists, Lori Damrosch, Harold Coe, Sean Murphy, and Nilofer Oral. All right. As our colleague who departed this year, sadly, Vednanda used to say, it's time for wine and cheese for world peace. Let's go to the next room and celebrate, and I will see you over there. Thank you, everybody.
That's a great answer that you spoke. That's actually worth quoting.
Sorry.
It's,